I'm Dr. Om Prakash Tiwari. Presently, I'm teaching in Berkeley University Law Department, and my topic is judicial review. Actually, judicial review comes within the purview of judicial process. This topic, the subject judicial process, is taught in LLM first year, first sem. So today I have to describe the things which are enumerated under these systems, that is the judicial review, judicial activism, judicial overreach, and judicial restraint. And we will talk also about some other things which are connected with these topics. So first we will talk about the renowned case Marwari versus Medicine. This case comes from USA. Supreme Court of America first time thought about the judicial review in this case, and our system, our judicial legal system, has adopted this principle from that country. But it is not like that. In our constitution also, if you talk about Article 13, class 2, 3, 4, then you will find that there is also a provision that the state shall not make any law which abridges or infringes the fundamental right of a person. So how this provision is there? Actually, this provision is for the safety of the citizen. If any law is made by the state government, by the state legislature or the parliament, and if anyone aggrieved by this law or this legislation or enactment violates the fundamental right of a citizen, then that person can go directly to the Supreme Court and challenge it before that court. High courts are also having power to review, and this article, which is Article 13 of our Indian Constitution, has given a hand to the Supreme Court. This Constitution guarantees the rights of the citizen, and it protects the fundamental rights of a citizen and the persons who are residing here, even though they are not citizens. तो ये जुडिशल रिव्यू का जो कॉन्सेप्ट है वो मारवारी वर्सेस मेडिसन के केस से आया. पहली बार इस केस में न्यायिक पुनर्विलोकन, न्यायिक समीक्षा की बात सामने आई, और इस कॉन्सेप्ट को हमने भी यहाँ पर अपने इंडियन लीगल सिस्टम में अडॉप्ट कर लिया. और इसी तारतम्य में हमारे भारतीय संविधान के अनुच्छेद 13 में भी इसकी व्यवस्था की गई कि अगर कोई स्टेट लेजिस्लेचर यानी राज्य विधानसभा अथवा पार्लियामेंट, लोकसभा, कोई ऐसा कानून बनाती है जो हमारे संवैधानिक अधिकारों का हनन करती है, संवैधानिक अधिकारों विशेष रूप से हमारे फंडामेंटल राइट्स को हनन करती है, तो उसको हम सीधे हाई कोर्ट्स या सुप्रीम कोर्ट में चैलेंज कर सकते हैं. और यदि सुप्रीम कोर्ट थिंक्स दैट यस, ऑफ कोर्स देयर इज अ वायलेशन of any fundamental right of a citizen, then Supreme Court can declare this such kind of law as null and void. So now the question is that why the concept of judicial activism. Basically, and we can say that initially the duties of courts, that is the high courts, I mean high courts and the Supreme Court, they have a given power and jurisdiction to decide the cases. Under various enactments, that is the CRPC, CPC, there has been provision that when, how, and in what cases high courts can take the issues and solve the resolve, whether as a matter of revision, as a matter of repeal, appeal, and review also. So, this is the concept of judicial activism, that if the state government or the central government or any executive body, whether it comes under the state or the center, if Parliament makes any law which is not good, which is not in the public interest, which is not in the interest of justice, or any kind of law which is made by the state legislature, or any executive orders which are not good to the citizen, then it can be reviewed by the Supreme Court. And as and when, if it is necessitated, required, then concerning High Court also take the action and consider about these laws. And if it is found that there is this is not good law and it violates some constitutional rights of a citizen or of a person, then it can be declared null and void. The general principle of court proceedings are that they have been given the rights, and within the purview of their rights they have to decide the cases. But in failure, why this concept of judicial activism arise is only that the concerning bodies, that is the central government and the state government or the executive body, that like municipal corporation, electricity board, MPRCTC, and many other corporations, they are not going to perform their duties well, and somehow, and at some stages it is found that they have been given power but they are not exercising that. And many times it happens that due to their lethargies and due to their lack of sense for performing their duties, the persons are bound to go and knock the door of the Supreme Court and the High Courts. So this is the concept of judicial activism. अगर इसको हम थोड़ा और आगे बढ़ाएं तो ये कह सकते हैं कि न्यायिक सक्रियता का सिद्धांत हमारे यहाँ तब विकसित हुआ जब हमको ये पता चला, जब हमारे सुप्रीम कोर्ट को, हाई कोर्ट्स को ऐसा लगने लगा कि सेंट्रल गवर्नमेंट या स्टेट गवर्नमेंट या गवर्नमेंट की कोई भी निकाय जो बॉडीज़ हैं, जैसे लोक निर्माण विभाग है, विद्युत विभाग है, महानगर पालिका है, नगर निगम है, नगर परिषद है, उनका कोई अधिकारी है जो उसको काम सौंपा गया है उसको ठीक से नहीं कर पा रहा है और उससे जनता को दिक्कत हो रही है। तो ऐसी स्थिति में एक हमारे यहाँ पब्लिक इंटरेस्ट लिटिगेशन का कॉन्सेप्ट आया बहुत पहले, जिसको लोकहितवाद कहते हैं। उसमें कोई भी ऐसा व्यक्ति जो किसी समूह के अच्छाई के लिए, एक ग्रुप के गुडनेस के लिए वो कोर्ट जा सकता है और पब्लिक इंटरेस्ट में पिटीशन फाइल कर सकता है। और कोर्ट को ऐसा लगता है कि हाँ, ये जो कंसर्निंग अथॉरिटीज़ हैं वो अपने काम को ठीक ढंग से नहीं कर रही हैं, तो ऐसी स्थिति में उनको वहाँ से गाइडेंस दी जाती हैं और कई तरह के डायरेक्शंस भी दिए जाते हैं। तो ये एक अलग अप्रोच है जो सामान्य रूप से हायर कोर्ट्स की जो ड्यूटीज़ हैं, जो उनका काम है, वो निश्चित रूप से रिवीजन, अपील एंड ओरिजिनल जुरिडिक्शन में उनको अपने केसेस का निपटान करना है। बट Chunki Supreme Court is the guarantor and protector of the Constitution, and the guarantor and protector of any person of India, or the persons who are residing here as a person. So this has now become duty, absolute and pious duty, uh, goes to the Supreme Court, and it has to see that whether all the concerning organs of the state or the central government are performing their duties well or not. One thing which is prescribed under our article, that is Article 21. It talks about the personal liberty. In our Constitution, this provision says that no person shall be deprived of his life and personal liberty except according to procedure established by law. Now, there are many cases which have been decided by the Supreme Court in this regard, because personal liberty is a very, very important and vital part of a democratic country. The first case which comes under this topic was A.K. Gopalan versus the state of Madras, 1951. In this case, it has been said that protection of Article 21 is available only against the executive action, but legislative may deprive a person by making a law. Why the court says like that? Because in our Constitution, this provision, Article 21, it says that if any person or if any authorities is working within the purview of the law, that is, if there is a law and someone is performing their duties within that law, then it can't be said that there is any kind of violation of any right of citizen or a person. So in this case, गोपालन वाले केस में ये कहा गया कि जो आर्टिकल 21 का प्रोटेक्शन है ये केवल एग्जीक्यूटिव एक्शन के विरुद्ध ही है। अगर कोई एग्जीक्यूटिव बॉडी है और कुछ वो आदेश करती है जो ठीक नहीं है, तो उसके खिलाफ ही ये आर्टिकल 21 के अंतर्गत हम रिलीफ ले सकते हैं, लेकिन ये लेजिस्लेटिव के विरुद्ध नहीं है। मतलब अगर कोई कानून लेजिस्लेचर ने बना दिया है तो उस कानून को जब तक गलत नहीं ठहरा दिया जाता है, जब तक उसको नल एंड वॉइड डिक्लेयर नहीं किया जाता है, जब तक किसी कोर्ट ने उसको स्ट्रक ऑफ नहीं कर दिया है, तब तक उस आदेश या उस कानून की मान्यता है और हर व्यक्ति को उस कानून के अंतर्गत कार्य करना होता है। और यदि उस कानून के अंतर्गत कोई व्यक्ति या कोई भी बॉडी, कोई भी निकाय गवर्नमेंट की कोई काम करती है तो उसके ऊपर कोई सवाल नहीं उठाए जा सकते, कोई ऑब्जेक्शन नहीं लिया जा सकता। बट सिनेरियो चेंज इन द केस ऑफ मनेका गांधी वर्सेस यूनियन ऑफ इंडिया 1978. Now in this case, a new concept as far as our constitution is concerned, because in our constitution due process word has not been defined anywhere or discussed. This is the concept of America. There the theory of due process was promulgated and it was made by the American Supreme Court. There was a debate in Constituent Assembly also that what kind of things you should adopt, whether you have to take due process of law here or you have to take the procedure established by law. Then after a long deliberation, the committee and the persons involved to making the draft, they come to the conclusion that in our country there is no need to adopt the due process theory, and so finally procedure established by law was adopted and it was incorporated under Article 21 of the Indian Constitution. Since you are discussing and talking about the judicial activism, so you will say here that Supreme Court in a large number of cases it has decided and found that many things which are not incorporated under fundamental right, due to these judgments Supreme Court has come to the conclusion that such and such things are having a great significance in the life, and so it has been enumerated and it has been included in the part 3 of the Indian Constitution, that is the Article 21. There are many cases. The one is Sunil Batra versus Delhi administration. In this case, the accused Sunil Batra was sent back to the solitary confinement, and it was challenged before the court. Although this challenge was not accepted by the court, but the theory propounded is that if any kind of encroachment is being made to the liberty of a person, that is not constitutional. Then the case of Prem Shankar Shukla versus Delhi administration. In this case, the short story of case is that a person, that is Prem Shankar Shukla, was handcuffed by the police at the time of appearing and the time of presenting the accused before the court, and he challenged before the Supreme Court that it is unconstitutional because it is violative of the fundamental right and the personal liberty of a person. So in this connection, after going through many pros and cons, our Supreme Court held that handcuffing is unconstitutional. किसी भी व्यक्ति को, हालांकि इसमें कुछ हिदायत दी गई, कुछ डायरेक्शंस दिए गए कि कब और किन परिस्थितियों में किसी अभियुक्त को या किसी व्यक्ति को हथकड़ी पहनाई जा सकती है, उसके संबंध में गाइडलाइंस है। लेकिन आमतौर पे जनरली ये ऐसा कोई कानून नहीं होगा कि कोई अभियुक्त व्यक्ति है तो सिंपली दैट ही इज एन एक्यूज्ड ही कैन बी हैंडकफ्ड। इट इज़ नॉट लाइक दैट। यहाँ पर क्लियर किया गया कि यदि कोई व्यक्ति है, कोई अभियुक्त है जिसके कस्टडी से भाग जाने की पूरी संभावना है और ये एक रीजनेबल अप्रीहेंशन है कि यदि इस व्यक्ति को हम हैंडकफ नहीं करते हैं तो ये हमारे कस्टडी से भाग सकता है और इस तरह से जस्टिस प्रभावित होगा, तो ऐसी स्थिति में ही उसको हैंडकफ करने की अनुमति होगी, अदरवाइज नहीं होगी। इसके बाद one case, that is the Mohini Jain versus the state of Karnataka, 1992. In this case, Supreme Court held that right to education is a fundamental right of a citizen. Although in directive principles it was said that free education must be, and it should be done by the governments concerned, and there must be some efforts in that direction that education should be free to some extent. So in this case it was held that right to education is a constitutional right, is a fundamental right. But in Uni Krishna versus the state of Andhra, 1993 Supreme Court, it was confined only to the 6 to 14 years child. Means between 6 to 14, if there is a child and who claims that I have a right, I have a fundamental right to education, then he is saying correct. as per the directions and as per the holdings of the Supreme Court. Then the next case is Satwan Singh versus APO, Delhi. In this case, right to abroad was regarded as a fundamental right. यानी अगर कोई व्यक्ति बाहर के देश में किसी जाना चाहता है, विदेश जाना चाहता है, तो वो उसका एक मौलिक अधिकार है, ऐसा सुप्रीम कोर्ट ने इस केस में, मोहनी जाने वाले केस में माना। फिर that is not Mohini case, it is the Satwan Singh case. Then Subhas Kumar versus the state of Bihar. In this case, it was held that right to get the pollution free air, right to get the pollution free air, यानी प्रदूषण मुक्त हवा प्राप्त करने का अधिकार हर एक व्यक्ति को है, और इस तरह का कोई अधिकार ये एक मौलिक अधिकार की श्रेणी में आता है। तो our Supreme Court has held that right to get the pollution free air comes under the purview of fundamental right. Then the next case is Olega Tellis versus Bombay Municipal Corporation. In this case, it has been held by the Supreme Court that right to livelihood, that is the very, very important factor in our country, because this is the big issue. A lot of persons are dying due to only that they have not acquired enough money to survive themselves. So, it is the fundamental right of a citizen to take food, at least 2 times foods are required to those persons who have no means to take themselves as a healthy man. So आजीविका का अधिकार ये भी सुप्रीम कोर्ट ने मौलिक अधिकार के अंतर्गत